Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, the Honorable Supreme Court of India directed the judicial academies to make two important case laws as a part of the curricula. So, you all know what is the Judicial Academy. Training will be given there. During the training, these academicians or judicial officers, while they are being given or imparted the training, they should know two important cases. They are, number one, Siddharth versus State of UP 2021. Siddharth versus State of UP 2021. Second is Antil, that is Satender Kumar Ansil versus CBI 2022. Why these two cases are important? So definitely for the judicial officers, at the same time they will be useful for the police officers, and ultimately they must be useful for the advocates also, because unless we know them, how can you produce the same stage judgment before the court? Friends, all of you may be aware of these two cases. I have made videos also previously, but anyway, for your convenience, I am giving a gist of these two cases. The first case is relating to 170 crpc. So this is Satender versus State of Uttar Pradesh 2021. In this case, Justice Sanjay Kishan Kaul and Rishikesh Mukherjee, he held that, please remember, Section 170 CRPC does not impose the condition that the accused should be arrested before producing along with the charge sheet. So 170 says cases to be sent to the magistrate when the evidence is sufficient. That means regarding the charge sheet. Of course, you know, according to 173 CRPC, the final report will be filed. Yes, final report means either closure report or the charge sheet. But here under section 170, when the evidence is sufficient, definitely they can send the accused to the court. So at the time of answer, normally the lower rank officers or judicial magistrates, they are under the impression that when once the charge sheet is filed and there is evidence against him, why he is not arrested? So in practical aspects, I will tell you, normally the police, after concluding the investigation, they will file the charge sheet. In the charge sheet, they will say, so there will be an annexure to the charge sheet. In it, they will say the case is involving so and so 6 accused. Out of them, 4 arrested, 2 not arrested. Then the first remark from the court will be, why did you not arrest these 2 accused? So it is not necessary. This is what this Siddharth case. So here in the case, please remember, the special judge is under the wrong or under the misconception that in every non-bailable and cognizable offence, police should arrest the person. Then what is the provision of 41 and 41A CRPC? You know, if no doubt there are certain offences which are non-bailable even though below 7 years. That is what is Arnesh Kumar judgment. So here, if the accused is cooperating, then there is no arrest for the accused. Then there is no arrest. So 170 CRPC does not mandate that the arrest should be mandatory. This year. So if the accuser cooperates, he need not be arrested. So in this connection, emphasis is laid in the case of Joginder Kumar versus State of UP 1994. So this deals with how the investigating officer should arrest the accused and the procedure. So please remember, actually in this case, say this Siddharth versus State of UP, actually the investigation has been pending prolonged for a long time, and this man, he has been arraigned as accused, and now the court says why he was not arrested. When he is cooperating in the investigation, what is the purpose of arresting him? So this is what you have to learn from this case. Now let us get to the other case, that is Satender Kumar Antil versus CBI 2022. So this bench is dealt with by Honorable Justice Sanjay Kishan Kaul, Abhay Srinivas Vokha. Please remember, This is regarding the under trial prisoners. So please remember, actually, the judgment starts like this. John E.E.D. in the Essays on Freedom and Power, he said, liberty is one of the most external essential requirements of the modern man. So they have given directions in this case, CBI. So they have arrested, they have given directions in this case that already time is getting on. So the directions you have to learn. Number one, why don't the government think of making a bail act? Because so many compulsions are there, so many conditions are there. People are imposing, the judges are imposing the conditions as they like. So better the government enact a bail act relating to the bails. There should be some act, right? Normally, the IO should use the powers and section 41 and 41A CRPC, that is giving notices to the accused person in cases where the punishment is below 7 years. So just you have to remember Arnesh Kumar case. And this case mainly emphasizes whenever the accused is produced before the court for remand. So the remand should not be given in a mechanical way. The judge has to satisfy whether the provisions of 41A CRPC were used or not. If so, the court can direct the police to use the powers under section 41A CRPC. So court has to be satisfied before remanding, and remanding is should not be done in a mechanical way. So this is important. And that too, now and then the High Court should undertake the exercise of finding the under trial prisoners. Please remember, who are not able to furnish surety, who are not able to get bail due to so many circumstances, and they may be released on bail using the powers under section 440 CRPC. What does 440 CRPC say? It is amount of bond and also the reduction thereof. The amount of bond can be reduced. He can be released on self-bail like that. So this is more important. So, under trial prisoners, this is most right from Hussein Ala Khatun case we have been discussing, and even the provision section 436 CRPC says that whenever a person is found to have spent more than half of the period of conviction, he has to be released on bail, even on self-bail also. Why they are languishing in jail? Number one, because they are not able to produce the sufficient sureties as required by the Honorable Court. There may be difficulty because whoever who comes as a surety for a criminal who has been languishing in jail for more than 3 years, so family background is also necessary. So all these things should be taken into consideration. And because the jails are being filled with the under trial prisoners, better to create a vacuum. Therefore, the remand should not be automatic or mechanical. So these two judgments are 100% important to judicial officers as well as to the advocates as well as the police officers also. So if you are thorough with those two cases, I think you don't commit any mistakes. So as advocates also, we must know about these cases, right? With this, I am concluding. Thank you very much.